Welcome to some very famous people you've never really heard of. Bite-sized biographies of the famous, the infamous, and the quirky in less than an hour. My name is Philip D. Gibbons, and there is more information about me, this podcast, and a bibliography at bitesizedbiographies.com. There are also photographs of many of the individuals and items mentioned in this podcast. At the conclusion of Part 2 of this presentation, there will be additional suggestions concerning further information about today's subject, the Dr. Jeffrey MacDonald murder case. If you have enjoyed this presentation, please like us at our Facebook page, Bite-Sized Biographies. Subscribe to my YouTube page at Noblesse Oblige. Please note that all of Bite-Sized Biographies are now available on Spotify. And tell a friend about Bite-Sized Biographies. Now let's continue with our story about Jeffrey MacDonald. Initially, Mildred Kassab did not want to hear any of her husband's conclusions. That her own son-in-law was responsible for killing her daughter and grandchildren was too painful for her to even contemplate. But remembering Jeffrey MacDonald sitting in her own kitchen the previous November and while furtively avoiding her gaze, detailed how he had supposedly killed one of the responsible intruders, and now hearing from Freddie that that was impossible, caused doubt to begin to creep in. Freddie's additional information became too convincing, and she reached what for her was a horrifying realization. Her daughter had literally been beaten to death by her own husband in the most terrifying and painful manner possible. And with this realization came the incredible guilt concerning her daughter's request only days before the murder to come to Long Island with her children. Mildred told her daughter to wait until spring and the completion of the Kassab swimming pool. The children would enjoy that so much better. Had Mildred Kassab missed her own daughter's cry for help? At the very least, she might have removed her from the vicinity of her husband, and Colette may have been able to personally discuss the dysfunction within the MacDonald household, possibly precipitating a completely different course of events. Additional revelations from the CID concerning MacDonald's numerous infidelities only reinforced the Kassabs' now mutual belief in their son-in-law's guilt, but also their rage at him personally. A crime of passion was one thing, but this kind of unfaithful behavior was beyond the pale. Their interaction with Jeffrey MacDonald dwindled, especially after MacDonald relocated to Southern California. Despite her proximity, Dorothy MacDonald also rarely spent any kind of FaceTime with the Kassabs. Following Mildred's treatment and surgery for breast cancer in February of 1972, Dorothy showed up unannounced at the Kassab household with some flowers for Mildred. After some brief pleasantries, Freddie formerly resolved to not discuss his actual opinions about Colette's murder before any official pronouncements, lost his patience, and finally unloaded several hours' worth of information that led him to the conclusion that Jeffrey MacDonald had killed his family. Dorothy remained silent during this interaction, and when Freddie was done, she unemotionally excused herself and left, possibly sent by MacDonald himself to gauge the Kassab's state of mind. She also relocated to Long Beach, California, only minutes away from Jeffrey MacDonald's residence, and never spoke with the Kassabs again. Over 3,000 pages of the CID's reinvestigation report was officially delivered to the DOJ in June of 1972. This compilation pointed to the guilt of Jeffrey MacDonald, but after an examination by the federal prosecutor for the Eastern District of North Carolina, it was determined that a prosecution of MacDonald would not occur based on the initial mistakes of the CID, only circumstantial evidence, and the effort and expense required to pursue what most likely would result in a not guilty verdict. After several letters to high-level DOJ officials were rebuffed with similar rhetoric, Freddie Kassab decided to go public. By February of 1973, he supplied an interview to the Long Island newspaper Newsday, detailing his efforts to get the case reopened, his reasoning concerning the guilt of his son-in-law, and he and his wife's frustration over the lack of prosecution. MacDonald was briefly quoted in the piece, essentially refusing comment. Kassab wasn't done with his publicity campaign. A MacDonald story next appeared in the New York Daily News, a story that indicated that the DOJ had received new evidence and was possibly on the verge of placing the evidence in front of a grand jury. This was actually not true, but certainly seemed to rattle the cage of Jeffrey MacDonald to the extent that he reached out to a former advocate, Allard Lowenstein. Lowenstein was now an ex-congressman and liberal activist who had initially supported Jeffrey MacDonald during the investigation by the Army. Over time, and as MacDonald asked him to get specifically involved in the event of an actual prosecution, Lowenstein gradually came to the conclusion that MacDonald was guilty. While diplomatically extricating himself, it most likely became clear to MacDonald that Lowenstein was no longer convinced of his innocence, and he broke off any interaction. Now most likely desperate for any actual information concerning the DOJ's possible activity, MacDonald was again attempting to speak with Lowenstein. Instead, Lowenstein called Freddie Kassab to discuss Freddie's current state of mind. During their conversation, Lowenstein made it clear that he believed MacDonald was guilty, and Kassab told him to stay away because he truly believed that there was going to be an indictment. Lowenstein ultimately did not respond to MacDonald and never spoke to him again. Possibly coincidental, Jeffrey MacDonald called Freddie Kassab only days after this exchange. Kassab was in the habit of taping most of his phone calls concerning the case. Sometimes these recordings were indistinct, as in this instance, but the recording does pick up MacDonald's rage and anger during this conversation. On the call, Kassab quickly confronted MacDonald with his knowledge of MacDonald conducting an ongoing sexual relationship while confined to his bachelor officer quarters only a short time after the murders. As would become typical in the next few years, MacDonald would flatly deny any allegation that remotely contradicted his perspective and self-image of himself as a devoted family man and innocent victim of a malicious prosecution. At the top of his voice, he yelled at Freddie for even believing such a thing, attempting to deflect such behavior by claiming that he was routinely approached by women during the investigation and that the CID's affidavit was a complete fabrication. When Kassab said he had personally spoken to the woman in question, MacDonald erupted, calling Kassab disloyal and continuing to deny that anything untoward had taken place and that no one had suffered more than him. Perhaps aware that his demeanor with Freddie was additionally alienating, MacDonald quickly sent a letter to Mildred Kassab claiming that any infidelities on his part were brief encounters and very rare, that Freddie was being irrational, and that no one hurt more than he did over the murders, again making himself out to be the major victim of the entire incident. Despite the internal domestic drama of the Kassab-MacDonald relationship, years passed with the continuing letters passing between Fred Kassab and bureaucratic responses from various individuals within the DOJ and CID. The CID eventually reiterating to Freddie their own frustration over the lack of prosecution of the case. On April 30th, 1974, Freddie and Mildred Kassab ratcheted up the pressure on the DOJ. As legally entitled, they filed a citizen's complaint in front of the chief judge of the federal district court in North Carolina, one Algernon Butler. In this complaint, they asked him to review the 3,000-page reinvestigation and letters from DOJ personnel suggesting the prosecution of MacDonald, letters ultimately ignored by DOJ higher-ups. They also asked that upon review of this information that the judge either issue a warrant for MacDonald's arrest or the convening of a grand jury, regardless of the DOJ's lack of consent. Butler did not accept the complaint, but he did promise to inquire of the DOJ and the relevant U.S. attorney as to their attitudes concerning prosecution. Kassab's motion received publicity in Newsday, and he followed it up with a current review of the case, sending a 13-page letter to each and every member of the House and Senate Judiciary Committee, asking them to inquire of the DOJ as to why it still refused to move forward in any meaningful way. When some of these politicians, including the House chairman of the Judiciary Committee, Peter Rodino, now enjoying national prominence over the committee's handling of the Watergate affair, expressed an interest, the logjam started to break. Rather than another letter, the assistant attorney general himself, Henry Peterson, assigned the case for review to an experienced DOJ attorney named Victor Warhide. Warhide was no inconsequential bureaucrat, having prosecuted high-profile cases as far back as that of Axis Sally and the recent successful conviction of Illinois Governor Otto Kerner on various corruption charges. Warhide was a distinctive individual, 6'2", over 200 pounds, and rather intimidating, especially in the courtroom. He was quickly contacted and encouraged by a 27-year-old CID attorney named Brian Murtaugh. Murtaugh had been involved in processing information during the investigation and was convinced of MacDonald's guilt. Typically, such an experienced senior DOJ official might have told Murtaugh to buzz off. Instead, Warhide, after reviewing critical evidence, MacDonald's tape-recorded CID interview, and a visit to 544 Castle Drive itself, had Murtaugh transferred to his staff at the DOJ. Finally, on July 18, 1974, Warhide summoned Freddie Kassab to his Washington DOJ office. There he personally informed him that he believed that Jeffrey MacDonald was guilty of murder and that Warhide would request that a grand jury be convened in North Carolina. This grand jury would begin hearing testimony on August 12, 1974, and its first witness would be Jeffrey MacDonald. Although Bernie Siegel accompanied his client to Raleigh, the site of the proceeding, as was the case in all such circumstances, witnesses appeared by themselves without legal representation. MacDonald testified for 5 days. It was Warhide's intent to get him on the record about various fundamentals and then follow up with other witnesses to impeach his testimony and then confront him with any discrepancies. Warhide also summoned the FBI head of its chemistry section, Paul Stombaugh, to provide information about the forensic evidence that was collected by the CID at 544 Castle Drive. This information also involved the exhumation of the 3 graves of the victims, an exhumation intent on acquiring hair samples, which was permitted by Freddie Kassab, who actually had purchased and owned the cemetery plots. The chief result of the exhumation proved that a hair found in Colette's hand was her own hair and not that of a possible intruder. Stombaugh also observed that holes made in MacDonald's pajama top found on top of Colette MacDonald were not irregular or with jagged edges, but symmetrical, occurring when the top was not in motion, contradicting MacDonald's story that he used the top to fend off attacks from the intruders. Stombaugh maintained that the stab wounds suffered by Colette were the result of an old hickory brand knife and not an also present and bent Geneva forge knife, which MacDonald claimed he pulled out of Colette's chest before he gave her mouth-to-mouth resuscitation. The expert witness also testified that based on bloodstains on sheets and throughout the home, it was clear that Colette MacDonald's body had been relocated to the master bedroom, contradicting MacDonald's account. Most powerfully, Stombaugh was asked to provide a scenario of what he believed occurred on February 17th. He maintained that the murders began with an argument in the master bedroom that became physical, with MacDonald punching his wife in the face, bloodying her nose, and explaining blood that was on the pocket of MacDonald's pajama top before it was torn off. He added that he thought that Colette retrieved the wooden slat from the utility room and first hit MacDonald with it, explaining the one welt found on his head. MacDonald immediately took it away from her, the noise from the argument having attracted Kimberly into the bedroom, where she was struck in the head severely, accounting for the massive amounts of Kimberly's blood found near the bedroom entrance. At this point, Colette might have retrieved the dull-bent Geneva forge knife from the utility closet, the type of knife used to clean up while painting, and attempted to stab MacDonald. This would have explained one of the cursory cuts on MacDonald that were not clean, unlike the cut that punctured his lung, which was surgical in nature. Colette would have been no match for MacDonald, wielding the slat like a club, and within seconds after repeated blows, she would have been rendered unconscious. With that, MacDonald then picked up Kimberly, brought her back to her bedroom, and based on blood spatter evidence, delivered another blow, intent on ensuring that she was dead. At some point, Colette regained consciousness and ran into Kristen's room in an attempt to protect her only uninjured daughter. Here, MacDonald attacked her again with a ferocity that shattered both of her forearms. Large amounts of Colette's blood found in Kristen's room made it clear that she had been present during the struggle. At this point, MacDonald used a bedspread to drag Colette back to the bedroom. MacDonald then retrieved the sharper old hickory knife and systematically finished off his family, including his 2-year-old daughter. Hearing publicly for the first time a theory as to how MacDonald might have killed his family was extremely powerful. On January 21st, 1975, MacDonald returned to Raleigh to give testimony. If his initial testimony was somewhat defiant and stubborn in refusing to admit even the slightest imperfections in his marriage, this reappearance was disastrous. Warhide repeatedly undermined his credibility to the point where MacDonald became flustered, combative, and even sobbed emotionally. At one point, he became so unhinged that in trying to read a prepared statement, he extemporaneously began to shout, "I didn't kill Colette, and I didn't kill Kimmy and Christy, and I didn't move Colette, and I didn't move Kimmy, and I didn't move Christy, and I gave them mouth-to-mouth breathing, and I love them, and I love them now, and you can shove all your evidence right up your fucking ass." Jeffrey MacDonald immediately returned to California, but only 3 days later, 3 FBI agents appeared at his condo, informing him that he was under indictment for murder as returned by the North Carolina grand jury and subject to arrest, his bail revoked. He was taken to the Orange County Jail, held on $500,000 bail, eventually reduced to $100,000, which was posted, prompting MacDonald's release. A trial date was set for August 18th, 1975. For the prosecutors, this proved to be extremely optimistic. MacDonald's defense team had filed motions to dismiss the indictment on the grounds of lack of a speedy trial, the murder occurring 5 years earlier, and double jeopardy, in that the Article 32 process was a judicial event that had already cleared MacDonald. The trial judge, Franklin Dupree, had tossed out both motions, but only days before the trial was set to begin, a federal appeals court issued a stay and granted a hearing to further discuss MacDonald's appellate issues. In a 2-1 vote in January 1976, the Court of Appeals threw out the indictment based on the speedy trial issue. A further appeal by the DOJ wound up deadlocked 3-3, affirming the previous ruling. Only the Supreme Court could reinstate the indictment, but in a process that dragged on until May 1st, 1978, in an 8-0 decision, the Supreme Court reinstated the indictment, ruling that the appellate court did not have jurisdiction over a pretrial appeal. Almost a decade after the murder of Colette MacDonald and her children, her husband, Jeffrey MacDonald, would stand trial for her murder. Bernie Siegel once again led the defense, which took up residence in the Kappa Alpha fraternity house at NC State. Besides several other lawyers and legal assistants working on the case, Dorothy MacDonald was also staying at KA for the duration of the trial. In addition, Jeffrey MacDonald was also hosting Joe McGinnis, a best-selling author who had signed a contract to write a book about MacDonald and his case. MacDonald was to receive a percentage of any proceeds to fund his legal costs, a major motivation for this project. He also signed a release which allowed McGinnis to write the book as he saw fit, without any editorial input or approval from Jeffrey MacDonald. The housing was put together by Wade Smith, an attorney and former state legislature who was well connected in Raleigh, a member of MacDonald's team and seen as a counterpoint to Siegel, the hippie-looking guy from up north. In fact, for this reason, Wade Smith was tabbed to give the defense's opening statement. Siegel had also hired a Duke University-based psychologist to help with jury selection, and even MacDonald, by this time angry and sarcastic about even having to be in Raleigh, was pleased with the final makeup, which included an ex-Green Beret. As well as Dorothy MacDonald, Freddie and Mildred Kassab were in attendance every day. although they were no longer acknowledging the MacDonald clan. One huge negative for the prosecution was the untimely death of Victor Warhide in 1975 of a massive heart attack. In his place stood Assistant U.S. Attorney James Blackburn, assisted by Brian Murtaugh. Initially, the prosecution clearly suffered Blackburn halting and nowhere near the flamboyant and domineering presence of Victor Warhide. With much of the early testimony consisting of discussion of evidence, much was made of the botched investigation and mishandling of important items. But the prosecution got some breaks from the trial judge Dupree, who allowed the admission of the copy of Esquire magazine that contained information about the Manson murders that was very similar to behavior that MacDonald ascribed to his hippie assailants, an article that MacDonald undoubtedly read. Dupree also allowed the admission of the analysis of Paul Stombaugh as it concerned the blue pajama top. Dupree excluded the Colonel Rock Article 32 report, which literally stated that the charges against Captain MacDonald were, quote, not true, maintaining that any jury hearing that couldn't possibly remain impartial. Another critical exclusion was the extensive psychiatric testimony and analysis performed by the defense, ostensibly to prove that Jeffrey MacDonald was psychologically incapable of committing such a crime. Judge Dupree ruled that as an insanity defense was not being utilized, such conjecture was merely that, and such testimony would only be contradictory, with expert witnesses both for the prosecution and defense merely confusing the jury and needlessly extending the trial. Again, Paul Stombaugh of the FBI testified, providing numerous forensic elements that contradicted MacDonald's version of events. These included the fact that no knife cut in MacDonald's pajama top corresponded to the cut that pierced his chest and almost collapsed his lung, indicating that the top was already removed and the cut was self-inflicted. The round aspect of the ice pick holes, as opposed to what should have been shredded or uneven holes, while, as he claimed, he used the shirt in a defensive manner had he been involved in a struggle while these were made, and the fact these holes lined up perfectly when the garment was folded on Colette MacDonald's chest indicated that these holes were made while Colette was stationary, and not while Jeffrey MacDonald was struggling with an intruder. As stated during the grand jury proceedings, the knife used to stab Colette MacDonald was the old hickory knife and not the duller Geneva forge knife MacDonald claimed to have removed from Colette's chest. Additionally, stains on a sheet found in the master bedroom indicated that it had been used to carry Colette's body back into the bedroom. By the conclusion of Stombaugh's testimony, Bernie Siegel, frustrated by Judge Dupree's earlier ruling concerning the expert's admissibility, began a sarcastic and aggressive attempt to discredit the FBI official. This led to numerous outbursts by Siegel and contentious sidebars that only dissipated any collegiality remaining in the judge's interactions with the defense, especially after Siegel gave a lengthy interview criticizing Stombaugh's qualifications and calling his observations complete fabrications. This did little to endear him to the judge. Another highlight was the visit of the jury to 544 Castle Drive. Although Siegel objected to this enterprise, nevertheless he had MacDonald appear at the location, even entering the dwelling for the first time since the night of the murders. Numerous neighbors greeted MacDonald and yelled encouragement as he made his way through the proceeding. It was not long after this that the tape of MacDonald's interview of April 6, 1970 was played in open court. For some jurors, this was the beginning of creeping doubt about MacDonald's innocence. Both his tone and the content of his answers seemed off and evasive. Sensing that the trial might be getting away from him, Siegel then decided to go for broke and call Helena Stokely to the stand. But they would have to find her first. Her parents were subpoenaed and testified that they had no knowledge of her whereabouts. Privately, Helena's mother told the defense that Helena was a complete mess and of no use to anyone. Judge Dupree issued a bench warrant in any case, and Stokely was located in South Carolina and transported to Raleigh by a U.S. Marshal. Allowed to question her, Bernie Siegel spent hours attempting to get her to admit to involvement in the MacDonald murders. First soothing and conciliatory, and eventually confrontational and demonstrative, Siegel failed to get Helena to budge. She insisted that she had not been in the house and didn't even recall making any of the incriminating statements that other witnesses claimed that she previously made. Siegel even attempted to reintroduce her to some of these witnesses, friends, or ex-witnesses without success. Helena again merely stating she couldn't remember anything about it. Even after forcing her to look at some crime scene photos, she remained adamant. She couldn't testify to something she couldn't remember. On the witness stand, she gave some details about her extensive drug and health issues, and for the defense, recounted what she had done on the nights of February 16th and 17th, mostly taking mescaline and riding around in a car with no specific memory of anything until she returned home at about 5 in the morning. If the defense felt at least this much of an admission of her roaming the streets of Fayetteville with other drugged-out hippies on the night in question might supply some reasonable doubt, Jim Blackburn's cross-examination was quite damaging. He got Helena to admit that she rarely wore her blonde wig because her boyfriend Greg, present on the night of the murders, didn't like it. He also got her to state emphatically that she had never been in 544 Castle Drive at any time and had never seen Jeffrey MacDonald until she observed him that morning in the courtroom. She also, when asked specifically by Blackburn if she had killed Colette MacDonald or her children, Helena Stokely replied in the negative. Blackburn also got her to admit that such blackouts of memory for her were not unusual. Obviously, based on her history of drug use, her lack of credibility as a witness in any way for the defense would be obvious to the jury. But Bernie Siegel was not done yet. If he couldn't crack Helena, he could at least present a series of witnesses who could testify as to what Helena had told them regarding the MacDonald murders. The prosecution objected to such evidence as hearsay without corroboration. Dupree listened to all 6 of Siegel's witnesses with the jury out of the courtroom and then adjourned the case for the weekend. On Monday morning, he ruled emphatically that all 6 of Siegel's witnesses were excluded. Siegel even tried to introduce testimony from a lawyer on his team who claimed that she spent much of the weekend with Helena Stokely in an attempt to help her with getting a motel room on the defense's dime, and that Helena had again incriminated herself. Dupree didn't buy that either. It was now Jeffrey MacDonald's turn to testify. On the eve of his testimony, Siegel cautioned him against being arrogant or combative, attitudes which hurt him badly during the grand jury proceedings. On August 23, 1979, after only a few questions from Bernie Siegel, Jeffrey MacDonald began to sob on the stand. For 5 hours, Siegel had MacDonald discuss his married life and his children, sharing photos and holiday cards with affectionate greetings and pleasant events like going to the beach, Halloween, and Christmas time. Extremely effective, this testimony elicited emotional expressions from jurors and spectators, and from some even tears. Siegel went on to get reaction from MacDonald after viewing crime scene photographs, a description of his married life leading up to the incident, and his life since the murders. He closed by having MacDonald read the last letter Colette ever wrote to him, a very affectionate note reminiscing about some of their best times together, written while he was at Fort Benning only 6 months before her murder. It was another effective technique which clearly emotionally impacted the jury. Jim Blackburn decided that his cross-examination would center on the forensic evidence. Concentrating on adultery or character would not be sufficient enough to prove that Jeffrey MacDonald had murdered his family. The prosecutor knew that to accept such horrifically brutal behavior meted out by a husband and father, the jury would need to be practically forced to accept that there was no other alternative explanation. Understanding this to be an extremely high bar, Blackburn began his cross-examination, and he received a timely gift, that of the demeanor and posture of the defendant himself. All of the emotional capital that Bernie Siegel had built up in the courtroom and the jury box quickly dissipated with Jeffrey MacDonald responding to the most basic questions with sneering sarcasm and dismissive evasion. Gone was the sobbing husband and father who had generated so much sympathy and disbelief that he could even be capable of such an act. Blackburn methodically reviewed every piece of evidence that contradicted MacDonald's story, shaping his assertions in the form of a question, asking if MacDonald had any explanation for such evidence. The defendant repeatedly answered in the negative. After several hours, the trial broke for lunch. Both Smith and Siegel attempted to prop up their witness by maintaining that Blackburn hadn't laid a glove on him, but admonishing MacDonald to remain respectful even with his facial expressions and body language. In the afternoon, Blackburn repeated his tactic of phrasing a presentation of forensic evidence in the form of a question, for instance asking MacDonald if the jury found that the only blood found in the sink is type B blood, MacDonald's blood type, did he have an explanation for that? MacDonald merely answered no. Blackburn then asked if at any time MacDonald had used a scalpel or any other instrument to inflict an injury on himself at the bathroom sink. MacDonald's answer was merely, "I did not." Bernie Siegel repeatedly objected to this line of questioning, but was overruled every time. After spending much of the afternoon in a similar fashion, Blackburn then concluded his cross-examination of MacDonald. The defense team was quite confident that their client had sailed through the process with flying colors. There was nothing left but the closing arguments. Brian Murtaugh reviewed again for the jury the actual forensic evidence and the significance. Jim Blackburn then solemnly emphasized the physical damage to Colette MacDonald and her children, the broken, shattered forearm, overkill stab wounds, the brutal kill shots from the wooden club, and especially emphasizing the defensive stab wounds on Kristen MacDonald and the additional wounds to the defenseless 2-year-old, 33 in all, administered as she was cradled in the lap of her killer. Blackburn then contrasted these wounds with the testimony of the 3 doctors who treated MacDonald at the hospital, maintaining that at most he might have suffered one potentially fatal wound. What reason would a violent gang of intruders have to so viciously murder a housewife and her helpless children and then barely injure the most potentially dangerous individual in the household, merely leaving him in the hallway unconscious? And after heaping such a murderous attack on the household, not removing a single item of value or even the cache of all kinds of powerful drugs MacDonald had stored in a closet. Blackburn then addressed the character witnesses who testified on MacDonald's behalf as meaningless, stating, "If we convince you by the evidence that he did it, we don't have to show you that he is the type of person who could have done it." After a 15-minute break, Blackburn resumed, and as he again spun together the story of what happened on February 17th with numerous citations of specific forensic evidence, he punctuated it with an intensity that built to a powerful close. Finally, he said, quote, "I ask you to think and remember Colleen, Kimberly, and Kristen, and so in the future, should you say a prayer, say one for them. And if in the future you should light a candle, light one for them. And if in the future you should cry a tear, cry one for them. It is time, ladies and gentlemen, it is so late in the day, it is time someone speak for justice and truth and return a verdict of guilty against this man." Bernie Siegel was supposed to be Jeffrey MacDonald's ace in the hole, a heavyweight against veritable amateurs. The plan was for him to speak for 2 hours about the inconsistencies and circumstantial nature of the case, followed by Wade Smith's good old boy admonition that this Green Beret Captain Dr. All-American lad couldn't possibly have slaughtered his family for absolutely no reason. Then Siegel would return for 15 minutes of railing against each of the bureaucracies who took 9.5 years to visit such disrespect and unfairness on his client, the defendant. That was the plan. Although he had a wristwatch, Bernie Siegel, either out of ego or confusion, delivered what was nothing more than a general rant of anger against the government and the prosecution, his repetitive and histrionic language in direct contrast to Blackburn's serious but sincere delivery. It was 3 hours and 10 minutes into his presentation when Judge Dupree reminded him that he only had 5 minutes left, Siegel having not even got to the basic arguments he wished to include. At the conclusion of Siegel's time, in which he discussed Helena Stokely for the final 4 minutes, Judge Dupree called a recess. Jim Blackburn was entitled to a 40-minute rebuttal. His fellow North Carolinian Smith asked him for the favor of 10 additional minutes. Blackburn, knowing that over the next few years they would cross paths again, the prosecutor agreed. Wade Smith, with such limited time, could do little more than revisit the notion that a father and a husband, especially this man, wasn't even capable of such behavior. It was an emotional appeal. but with such little time, it had little more substance than emotion. Blackburn then delivered a 20-minute summation that was no less eloquent than his earlier presentation, and with that, the case went to the jury. They would be dismissed for the evening and begin deliberations the following day. Jeffrey MacDonald was so confident, despite the botched summation, that the jury couldn't possibly convict, that he had one of the legal assistants make a reservation for him and his new California girlfriend at a hotel in New York, with reservations at a top Italian restaurant. There was even talk as to who would speak first at the post-trial news conference, Siegel or MacDonald. Wade Smith was probably not so confident. He spent the day away from the defense's private courthouse offices, sitting at the defense table in the vacant courtroom. Then, suddenly and surprisingly, after only 6.5 hours of deliberation, a court clerk announced that there was a verdict. The principals quickly gathered in the courtroom, and Judge Dupree signaled that the jury be brought in. The very first juror through the door, the former Green Beret that MacDonald had joked would never convict him, was the first person who walked back into the courtroom. He was downcast, but tears were visible on his face. The second juror also was crying. The others entered with similarly emotional expressions, and like an ominous thunderclap, it was immediately apparent what had transpired regarding the verdicts. Jeffrey MacDonald was convicted of the second-degree murder of Kimberly and Colette MacDonald and the first-degree murder of Kristen MacDonald. The jury reasoned that the murder of Kristen was a deliberate and premeditated act designed to bolster his assertion that a pack of intruders had attacked everyone. Dorothy MacDonald added to the emotional atmosphere within the courtroom. Upon hearing the verdict, she fled outside, but her wailing was audible within the court itself, other jurors also audibly crying. Before passing sentence, Dupree asked if the defendant had anything to say. MacDonald merely stated, "Sir, I am not guilty. I don't think the court heard all of the evidence." With that, Dupree issued his own, much more impactful rebuke. He sentenced Jeffrey MacDonald to 3 life sentences to be served consecutively, not concurrently, which ensured that it would be many years before MacDonald could even be considered for parole, in effect, a veritable life sentence. A U.S. Marshal approached. MacDonald, now a convicted murderer, was placed in handcuffs and led out of the rear of the courtroom. MacDonald was denied bail during his pending appeal, filed with the Fourth Circuit Court of Appeals, and he was transported to serve his time at Terminal Island near Long Beach, California. He began a feverish correspondence with writer Joe McGinnis, possibly presuming that the sooner a book was released detailing his unjust conviction and stellar background, the sooner the public would clamor for a reversal of such an injustice. McGinnis spent several weeks living in MacDonald's condominium, wading through his subject's extensive files and unearthing various documents, not all of them complimentary. A psychiatric profile commissioned by the prosecution in August of 1979, which Siegel had prevented McGinnis from previously reading, but reviewed by Dupree during his denial of bail, indicated that MacDonald may well have been a psychopath prone to violence, had deep issues concerning women, latent homosexual tendencies, and even homicidal propensities. McGinnis then found a collection of notes that MacDonald had written during the military investigation detailing his specific daily activities. These included that he had lost 12 to 15 pounds at the behest of the boxing coach and had done this with the consumption of a drug known as esketrol, consisting of amphetamine, a common component of diet pills in the late 60s before such a drug was found to be both dangerous and illegal. Esketrol was also found to have dangerous side effects that included psychosis and was voluntarily removed from the market by its manufacturer in 1980. In his notes, MacDonald referred to consuming 3 to 5 capsules of the drug over a 4-week period in which he lost weight. He did not indicate over what time period this drug intake occurred, but based on his weight loss and no other factors accounting for such a weight reduction, his consumption of esketrol was most likely habitual during the time period leading up to the murders. Still, none of this was public knowledge when on July 29, 1980, the Fourth Circuit Court of Appeals, by a 2-to-1 vote, not only threw out MacDonald's conviction, but dismissed the original indictment itself. Their reasoning centered around MacDonald's right to a timely trial being violated and the possibility that Helena Stokely might have been more reliable as a witness if it had not taken so long for her to testify. An appeal by the government to rehear the case in front of the entire Court of Appeals resulted in a 5-5 ruling by the Fourth Circuit affirming the initial appellate decision. Jeffrey MacDonald was already released from prison and back at work at his old job at St. Mary's Medical Center, Director of Emergency Medicine. The government then appealed to the Supreme Court, which agreed to hear the case. For the second time, they ruled against MacDonald 6-3, stating that his right to a speedy trial was not violated, as he was not under indictment for much of the time in question, and in a case involving such a complicated murder, the federal government, acting deliberately, was acting in good faith. Once again, Jeffrey MacDonald found federal agents pounding on the door of his Ocean View condo, placing him in handcuffs while his 20-something girlfriend and fiancé sobbed in disbelief, only hours after Judge Dupree again revoked his bail and remanded him back to prison. In August of 1982, the Fourth Circuit Court affirmed MacDonald's conviction, rejecting his other various points of appeal. His appeal to the Supreme Court was quickly denied on January 10, 1983. 4 days later, Helena Stokely was found dead in South Carolina. Deceased for some extended period of time, her 7-month-old son, the product of a union with an individual serving 15 years for sexual assault, was found barely alive in the same home. Stokely's autopsy revealed that at the age of 30, she died of cirrhosis of the liver, further complicated by hepatitis. From his new prison cell in Bastrop, Texas, MacDonald called Helena's death suspicious. He was already working with Ted Gunderson, a former Green Beret private investigator prone to wild conspiracy theories, and a new attorney having parted ways with Bernie Siegel. MacDonald claimed to have new evidence that would exonerate him and vowed that a new appeal would be filed shortly. But a development completely out of MacDonald's control would catapult the case into a rarefied status of public scrutiny with the fall 1983 publication of Fatal Vision by Joe McGinnis. A major bestseller, quickly hailed as a true crime classic, the book was a devastating portrayal of not only Jeffrey MacDonald as unambiguously the murderer of his wife and children, but also a manipulative, compulsive liar and utterly narcissistic psychopath. Conceived as a means of revealing the MacDonald case as a travesty of justice, instead millions of readers would undoubtedly conclude that the doctor was exactly where he belonged. Among the many revelations contained in the book was the fact that on the night before his marriage to Colette MacDonald, Jeffrey MacDonald left a negligee in the automobile of his former high school girlfriend, Carol Larson, also known as Penny Wells. Immediately after the murders, Larson had moved to California, and when MacDonald relocated there for the first time, she met him at the airport and they lived together briefly. While any romance was absent for several reasons, this did provide a possible motive for the murders, MacDonald never having fully emotionally given up on Carol Larson. This was only one of the many secrets and lies revealed in Fatal Vision. But if McGinnis's account of the murders could be written off as the biased or even deliberate product of a slanted agenda, a 60 Minutes interview of MacDonald in September of 1983 visually reinforced his tendency to reflexively lie in response to facts he found threatening or that raised questions about his behavior. Mike Wallace read from some of the unpublished manuscript of Fatal Vision about MacDonald's rapid weight loss of 12 to 15 pounds in early 1970. MacDonald denied this on camera, indignantly stating that he never stated to anyone that he lost 15 pounds. "I also wasn't taking esketrol," was his next statement. When Wallace read to MacDonald words from the doctor's own written statement prepared for his attorneys, he still continued to deny that he ever told anyone he lost 15 pounds and that he ever took esketrol. Then MacDonald glibly tried to criticize anyone attempting to conflate such revelations into unfairly branding him as a murderer, ignoring the blatant lies he spoke only seconds earlier. As Allard Lowenstein concluded years earlier in a conversation to Freddie Kassab, in eventually doubting both MacDonald's integrity and innocence, he'll say anything to anyone. In 1984, a year after Fatal Vision was released, despite signing several releases and agreeing that MacDonald was free to write anything he wanted about the case, Jeffrey MacDonald sued the author in court for $15 million, chiefly on the basis of fraud and breach of contract. Within months, his habeas corpus petition was denied, most of the evidence submitted centering on Helena Stokely and her alleged associates. This denial would be affirmed by the Supreme Court in October of 1986. In the meantime, the civil suit against McGinnis was bogged down by the publisher's insurance company asserting that as McGinnis was not sued for libel, they did not have to pay for a defense. Forced to litigate, McGinnis eventually received a favorable ruling, which took 2 years, the actual civil trial not beginning until July of 1987. A 6-person jury eventually deadlocked on the charges, the media consensus that they voted 5-1 in favor of MacDonald, but in actuality, they never got that far in deliberations, deadlocking 5-1 in only one of numerous questions and realizing they would never reach a consensus. Rather than go through another trial, McGinnis settled the case, again supposedly for $325,000, also perceived as being paid by McGinnis himself. In fact, McGinnis released $100,000 in escrow and royalties that MacDonald was entitled to under their original agreement, and was also paid another $225,000 by the insurance company. Freddie and Mildred Kassab then sued under Son of Sam laws. That was eventually settled with the Kassabs, Dorothy and Jeffrey MacDonald, and his attorney receiving a split devised by a Los Angeles judge. In the end, Jeffrey MacDonald only received $50,000, less than the royalties he would have received if he never sued in the first place. McGinnis would then be the subject of a prominent book written by a New Yorker staff writer, Janet Malcolm, entitled The Journalist and the Murderer. Malcolm began her work with the sentences, "Every journalist knows that what he is doing is morally indefensible. He is a kind of confidence man, preying on people's vanity, ignorance, or loneliness, gaining their trust, or betraying them without remorse." In attempting to portray McGinnis as dishonest and deceitful in both his depiction of and relationship with Jeffrey MacDonald, her thesis became a self-description. Having never attended the trial, spoken with McGinnis or others in terms of the facts as she presented them, as well as her attempts to portray a brutal triple murderer in a favorable light. Somehow this mess ranks 97th on the Modern Library's 100 best nonfiction books of the 20th century. Other books, including Fatal Justice and the high-profile Wilderness of Error, written by Errol Morris, also attempted to discredit McGinnis's conclusion. Morris, the anti-establishment documentarian behind The Thin Blue Line and The Fog of War, headed down the very familiar path of lambasting the original investigation and the Helena Stokely did-it theory that adds very little to, in any way, exculpate Jeffrey MacDonald. Fatal Vision was the high point of Joe McGinnis's literary career. He published 12 books that ranged from the mundane to the wildly successful, and passed away from cancer, age 71, in 2014. In the meantime, MacDonald's legal quest had continued with a demand for a new trial based on the prosecution improperly suppressing evidence. This would be denied by the Fourth Circuit Court, the denial affirmed by the Supreme Court in November of 1992. By late 1994, Dorothy MacDonald and Mildred and Freddie Kassab were all deceased, and former prosecutor Jim Blackburn, then in private practice, had pled guilty to forgery, fraud, and embezzlement of hundreds of thousands of dollars. He was disbarred and served a 3-year sentence, his crime having no effect on the MacDonald case other than casting doubt on the ethics of the prosecutors themselves. With the advent of more sophisticated DNA testing, MacDonald began to pursue appellate relief via testing of any potentially exculpatory hairs or fibers discovered during the investigation. This lengthy process would begin in the late 90s and be subject to extensive litigation. To help him in this appeal, MacDonald collaborated with Catherine Curich, a prison correspondent who asked how she could help facilitate his release. The couple were married in 2002, and MacDonald received a transfer to a federal prison in Cumberland, Maryland, to be closer to his spouse. They were able to meet only in the prison visiting room and could not share physical contact. In 2005, MacDonald also participated in a parole hearing, but when he maintained that he was factually innocent, his application was routinely denied, and his next parole opportunity set for 2020. In 2006, the Armed Forces DNA Identification Laboratory, chosen by MacDonald, released an analysis of blood samples and hairs related to the MacDonald case. In this analysis, they found that none of the blood or hair samples tested were matched to Helena Stokely or her boyfriend and possible assailant, Greg Mitchell. Instead, hairs tested came from either Colette MacDonald or, in the case of a hair that was too small to be tested microscopically, but removed from Colette's left hand, was matched to Jeffrey MacDonald. This report eliminated any basis of appeal for MacDonald via DNA testing or results. Additional appeals were filed concerning a 2005 allegation filed in an affidavit by a U.S. Marshal, Jimmy Britt, that he was present when Jim Blackburn threatened to indict Helena Stokely for murder if she in any way implicated herself during testimony during the original trial of MacDonald. This allegedly occurred before she was transported by U.S. Marshals to Raleigh from South Carolina. This motion was also denied, and although they were not accepted into the court record, the government did submit records indicating that Britt was in Greenville, South Carolina, and not Pickens, where Stokely was confined, and other marshals transported her to Raleigh. The judge ruled that Stokely's testimony was consistent with how she would have testified in any case and not altered in the interim. Jeffrey MacDonald would then spend more than a decade filing appeals on repetitive claims involving Britt, DNA, and Helena Stokely, frequently dragging out the process by asking for continuances. In one filing in 2015, he actually supplied a single exhibit as new evidence. The book favorable to him, entitled Fatal Justice, the 1995 analysis that claimed he was railroaded by the prosecution who suppressed evidence concerning Helena Stokely. In February of 2019, the Fourth Circuit affirmed its rejection of MacDonald's last attempt to vacate his conviction, leaving him with no additional appellate options. After 49 years, the MacDonald criminal murder case was at an end. One of the longest cases in U.S. history. It reached the Supreme Court a record 7 times, but MacDonald was not done yet. Although eligible in 2020, he continued to refuse to request a parole hearing. At the height of COVID in early 2021, his attorney filed a request for compassionate release, indicating that MacDonald was ill with chronic kidney disease and that he was in danger of contracting COVID while confined in a federal penal institution. This request for release was also denied. Although many internet accounts claim that MacDonald is still incarcerated in Cumberland, Maryland, today, according to the federal inmate locator, Jeffrey MacDonald is housed in a federal prison facility at Butner, North Carolina. This is not an insignificant development. The last prison residents of such high-profile malefactors as Bernie Madoff and Ted Kaczynski, a.k.a. the Unabomber, among others. The Butner complex also contains a medical facility for those in need of care for serious conditions. MacDonald indicated on his request for compassionate release that he suffers from a chronic kidney condition. If this is serious enough to require a transfer to Butner, Jeffrey MacDonald may be closing in on his final days, still having never admitted his guilt. Colette MacDonald's closest living relative, her brother, Robert Stevenson, probably summed it up best when asked if the case would ever end. Sure, he said, either when I'm dead or he's dead. Thank you for listening to part 2 of this podcast about Dr. Jeffrey MacDonald. Information for this podcast came from the books Fatal Vision by Joe McGinnis and Wilderness of Error by Errol Morris. There are also additional photographs, bibliographical and musical information at bitesizedbiographies.com. Thank you for listening, and please tell a friend about bite-sized biographies.